kids together. I'm going to have another child for him. How are we supposed to? How are we supposed to co-parent if we can't talk to each other?
Well, y'all can't co-parent. That's why we're here. Because he assaulted you. He's on probation for felony assault of you.
Underlying offense as well as Ms. Lopez here. She may come up in the court.
And sir, you're Brandon Bell? The best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay. And will he waive the formal reading of the motion?
So I.
Give me just a second to get back to that. Mr. Bell, in clause number 24, DCCR 1008, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation April 21st of 2025 for the second-degree felony offense of aggravated assault with a deadly weapon. That was a 5-year deferred probation. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count 1 alleges that you failed to immediately report to the community supervision officer your contact information. And is that true or not true?
I failed to. True or not?
It's just true or not true. You can explain later. So did you give them your contact information or not?
Yes, ma'am.
You did give it to them?
Yes, ma'am.
Okay, so that's not true. Count 2 alleges that you provided a urine sample May 29th of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true?
Yes, ma'am.
True or not true?
True.
Count 3 alleges that you provided a urine sample July 17th of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true?
True.
Count 4 alleges that you were at a location other than your residence at approximately 3:10 a.m. and 4:55 a.m. on July 10th of 2025 in violation of probation. Is that true or not true?
True.
Count 5 alleges that you failed to provide all records and documents required by the supervision officer within 30 days of their instruction. Is that true or not true?
Not true.
Count 6 alleges that you failed to provide verification of entering and successfully completing the BIP program, the Battering Intervention and Prevention Program. Is that true or not true? Have you done the BIP program?
No.
Okay. So that would be true that you haven't successfully completed it, right? Okay. Count 7 alleges that you failed to
I think I should say not in there, Judge. I'm sorry. He felt to not have any communication.
state wish to amend that to say not on number 7.
Yes, Judge.
Fail to not, any objection?
Objection.
So 7, hold on, let me make that. I'm printing it because it'll be easier for me. All right, so 7 says that you failed to not have all communication with the victim regarding your child through an approved third party by repeatedly appearing at the victim's house to, quote, see your children. Is that true or not true?
True.
Count 8 alleges that you admitted to the adulteration of your urine analysis on June 30th of 2025. And is that true or not true?
True.
You understand adulteration means? If the court could explain adult, I don't think you.
I mean, did you show up to probation and do either a fake urine sample or have some type of, what was it,
He admitted to drinking something that made his urine negative.
gotcha. So did you do that?
No.
You didn't? You just admitted it, but you didn't really do it?
Did you say it, or did you say that or not? That you admitted to drinking something?
So it says you admitted to the adulteration of your urine analysis, that which means you told your probation officer that you did something to make your urine analysis negative. Is that true or not true?
Well, any piss test
Urine test.
Urine, listen.
Urine test I failed with.
Listen to my question. I don't care about any of that.
Yes, ma'am.
Did you admit to your probation officer did you admit to your probation officer that you drank something or took something that would make your urine clean?
Not that I know of.
Okay.
Let's say not true.
Count 10, let's see. Actually, count 9. Hold on, I got I'm not a 5, 6, 7, 8. What I missed here? Count 9. So this goes over here. Alleges that you had contact with the victim of the offense, either in person, by telephone, via mail, or through a third party several times after being put on probation in violation of your order. Is that true or not true?
You said it again?
Have you had contact with the victim of the offense?
True.
And then count 10 alleges you are behind in your court-assessed fees as of July 17th, 2025 in the amount of $337. And is that true or not true?
True.
Did you enter your pleas of true to counts 2, 3, 4, 6, 7, 9, and 10 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true.
Yes, ma'am.
So we've got, I'm going to find those counts true. Ms. Lopez is here.
The crucial point here is that Judge West is separating the plea from the explanation. At this stage, true or not true determines whether Mr. Bell admits each alleged probation violation. Mitigation comes later. His true pleas to repeated THC positives, an unauthorized late-night location, failure to complete the battering intervention program, prohibited victim contact, and unpaid fees give the court multiple independent grounds to proceed. Notice that the judge carefully corrects confusion. Instead of simply treating every allegation as admitted, she marks disputed counts not true and confirms that the admitted pleas are free, voluntary, and factually accurate. That protects the record and makes a later challenge much harder. The most serious pattern is not the $337 balance by itself. It is the combination of drug use, unfinished intervention programming, and contact with the victim in a case involving aggravated assault with a deadly weapon. Do you think his attempts to explain the urine allegation improved his credibility, or did they make him appear evasive? The next question is no longer whether a violation occurred. The admissions establish that. It is whether Judge West sees this as correctable non-compliance or an escalating safety risk.
What? Let me look back at something real quick. When was the last drug test?
My last drug tested him on the 18th of August.
And it was negative?
It was negative.
And has there been any follow-up or treatment with spinal top?
You mean mental health or
Mhm.
drug treatment? Mental health, yes.
Okay.
Yes.
Okay.
Fever? Oh, wait, Your Honor, I apologize. August 18th was his last drug test, and he tested positive for THC. He has since been drug tested again in September, and it was negative. I gave you the wrong date there.
And I think the concern, if Ms. Lopez can kind of go into a little bit more detail about our conversation, is that he may be using synthetic, which doesn't show on the tests at probation. And there's obviously an issue with the no contact, which is why I have the complainant here. I don't think either one of them are adhering to this.
So, last known contact that you know of that's not in here, has there been any?
I was called by the complainant on Thursday of last week, and she admitted that they had been seeing each other that day. And she was angry, but it's very inconsistent whether she wants to be around him or not. Some days I get calls.
Well, but I told you,
You come back in front of you.
Just be quiet. Listen.
I told you can't have contact.
Yes, ma'am.
And you're the one that can go to jail.
Yes, ma'am.
Okay, based on all of these allegations, I realized that I reinstated a bond and we had a hearing, it looks like, where I ordered some spinal top, but it sounds like this is not going in a safe direction at this point for anyone. At this point, I'm going to find that it is in the best interest of our community, best interest of the victim, and based on all of the factors in 15.17 and the fact that you're on probation for an aggravated assault with a deadly weapon, I am going to make this, at this point, a no bond. You will go back with the bailiff. I'll reset your case for an updated pre-sentence report.
This is the hearing's decisive shift. Judge West is not imposing the final sentence yet. She is ordering no bond, returning Mr. Bell to custody, and resetting the case for an updated pre-sentence report and further testimony. Her reasoning is cumulative. Several violations were admitted. The August THC test was positive, required battering intervention classes remain incomplete, and probation reports fresh contact with the complainant despite a direct no-contact order. The allegation of possible synthetic drug use is only a concern, not a proven violation on this record, so the stronger legal foundation remains the admitted conduct and confirmed testing. The complainant's inconsistent willingness to see him may explain how contact keeps occurring, but it does not excuse him. He is the person on probation and therefore the one legally exposed to revocation and incarceration. Did you notice how the judge's focus moves from technical compliance to immediate safety? The original offense involved aggravated assault with a deadly weapon, so repeated access to the same victim carries far more weight than an isolated curfew or fee violation. By preserving the disputed allegations for later testimony, Judge West avoids deciding unresolved facts prematurely, while still acting on the risks already established.
We could have any other testimony at that time with regard to the other allegations that are still pending. If you have any witnesses, then...
Since she's here, do you want to elicit testimony from the victim or not? She is
Judge,
here.
what my preference would be, that she come up to be addressed by the court.
Yeah.
Ms. Bell. The nature of this plea originally, Judge, was obviously a little bit low. It was based on some cooperation, non-cooperation, cooperation, non-cooperation, which I believe is still the case. I don't know what
Look this way.
what is, I don't
You
know the
look this way.
relationship between the two of them. Obviously, I'm concerned for that. It's my understanding through Ms. Lopez that they're continually together, in that, in addition to Mr. Bell, she is also violating that no contact order by voluntarily engaging.
I think they have children together as well, is that right?
Well, that's why-
You're pregnant now, is that right?
But that's why I made the specific rule that they go through a third party to transfer kids, to see
And
kids.
the problem is that the third party is his mother, which is, I've told him multiple times, cannot be.
Cannot be. Okay.
It's not working.
You are pregnant with this child right now?
You said.
So here's the thing. I can't necessarily order you. You're not here in court on an offense. But he's going to jail today because y'all won't quit doing what I told him not to do. So it's that simple.
Can I say something? Whenever I did call the probation officer, technically he was already staying at the house. We both our names are on the house. He was already staying at the house. So when I went to the house, I just wanted him to leave because, me and the kids needed somewhere to go. And I called the probation officer on my own, but he was technically staying at the house already. I just wanted him to leave because me and the kids needed somewhere to go. And obviously we all couldn't be there.
Right.
But he haven't.
So did he not leave so that you and the kids could stay there, and that's why you called?
Yes, ma'am.
Okay.
But
then
he's been staying there.
all right. Well, then you know what you have to do. You're the one
I
on.
got out the house and I waited on my ride before my ride came.
Well, if you're staying at the house and you're, I'm resetting it for a sentencing hearing. If there's any testimony at that time, you can recall witnesses, and so we'll come back.
I would implore the court to admonish them that contact includes calls from the jail.
It does. Contact, communication. Contact doesn't just mean in person, all right? It means communication. So you can't call her from the jail. You can't talk to her, period.
Man, we have children together. We have 4 kids together. I'm going to have another child for him. How are we supposed to co-parent if we can't talk to each other?
Well, y'all can't co-parent. That's why we're here. Because he assaulted you. He's on probation for felony assault of you. So we're not co-parenting isn't where we're at right now. Right now, we're trying to keep you, that baby, and the rest of your children safe until I know he's following all the rules. He hasn't done the classes that he's supposed to have. He's using drugs. That's not safe for y'all. That's not co-parenting.
Man, we're going to have another baby.
I'm sorry. There's choices that both of y'all are making, and that's a choice that you're making to still be with somebody that assaulted you. You can go back, go.
Thank you, Judge.
You can go with the bailiff.
Judge West ends this hearing by drawing a hard line between co-parenting and court-ordered safety. Mr. Bell admitted violations of 5-year deferred adjudication probation, including THC use, prohibited late-night absence from home, failure to complete the battering intervention program, victim contact, and unpaid fees. Probation then corrected its testimony to confirm an August positive THC test and described contact between the couple. Against the background of felony aggravated assault with a deadly weapon against this complainant, the judge concluded that continued release was no longer moving in a safe direction. Importantly, this was not the final punishment. Judge West ordered no bond, remanded him to the bailiff, requested an updated presentence report, and set a later sentencing hearing where witnesses may be recalled and the disputed allegations can be litigated. That procedure matters because admitted violations support court action, while contested claims still require an evidentiary basis. The complainant's voluntary participation does not cancel the no-contact condition, and sharing 4 children does not authorize direct communication. The judge also clarifies that contact includes jail calls, not merely physical meetings, closing a route for another violation. The broader lesson is that probation is a package of enforceable conditions, not a menu. Would you view the complainant's explanation as mitigation or as further proof that boundaries have failed? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.